Hi there, everybody. Welcome back. Today we're going to talk about sovereign immunity and the 11th Amendment. All right, so let's start. What is sovereign immunity? This comes from the idea that the king can do no wrong under the law. I guess this is one of the perks of being the sovereign. You can't be sued in your own court unless you agree to it. So the question that's interesting to us in terms of federalism is what happens when an independent nation state becomes a state under the Constitution. So this was a real question at the time of the founding, and Hamilton actually came up with an answer. And you can find this answer in Federalist 81. He says, "To what purpose would it be to authorize suits against states for the debts they owe? How could recoveries be enforced? It is evident it could not be done without waging war against the contracting state, and to ascribe to the federal courts, by mere implication and in destruction of a pre-existing right of the state governments, a power which would involve such a consequence would be altogether forced and unwarrantable." So what this seems to imply is that there exists ahead of time this sovereign immunity that the states enjoy. And what Hamilton is saying is that the new Constitution isn't really going to do anything to change this. But that message doesn't appear to have gotten to the members of the early Supreme Court. In the case Chisholm versus Georgia, Georgia, the state, had ordered some supplies from a businessman from South Carolina. And of course, he delivered these supplies, but then was never paid. So the executor of his estate sued in the original jurisdiction of the Supreme Court. The legal question here was whether Georgia was subject to the jurisdiction of the Supreme Court. Georgia argued that it wasn't. The holding in this case was 4-1, and the Supreme Court held that yes, Georgia actually was bound to the jurisdiction of the Supreme Court. And the argument went like this. Article 3 lays out the original jurisdiction of the court, and some of the things that it includes are these disputes involving states. And so the court says, this means that we have jurisdiction. And it might be that at one point the state of Georgia had state sovereign immunity, but it doesn't anymore. And of course, they don't mention anything about the Federalist Papers or about Hamilton's conception of this sovereign immunity surviving the ratification of the Constitution. And perhaps this is because, they didn't really need to look back in time to these documents to understand what these words would have meant at the time of the founding, because really it still was the time of the founding, and these were all contemporaries. Now, Judge Iredell dissents in this case, and in his dissenting opinion, which is a very, very long, interesting opinion, he says, "A state does not owe its origin to the government of the United States in the highest or in any of its branches. It was in existence before it. It derives authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people." But this view didn't carry in the Supreme Court. However, it was quite compelling outside of the Supreme Court. We see almost immediately Congress hits back against the Supreme Court with the 11th Amendment. And within the span of about a year, this amendment was ratified. The amendment reads, "The judicial power of the United States shall not be construed to extend to any suit in law or equity, commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state." So interestingly, this is the first use of Article 5 to overturn a Supreme Court decision. And we'll see a little more of this farther down the road in the course. So what does this mean? As we're going to see today, this means states cannot be sued in federal court unless they agree to be sued, generally speaking. But there are some exceptions to this rule. And we're going to see how some of these exceptions evolve. First is this voluntary waiver of immunity. If a state agrees to be sued, it can be sued. There's also the potential for congressional abrogation of state sovereign immunity, and we'll see this in the Seminole Tribe case. There's also the possibility for states to be sued in order to stop an ongoing violation of federal law. Usually this means this would be a particular officer of the state would be subject to an injunction. And lesser entities of the state are not protected by this sovereign immunity. And so this might be cities or towns, and we see this mentioned in Alden versus Maine. Bad faith actions can also subject states to lawsuits in federal court. So a recent example of this might be something like the Bridgegate scandal, where New Jersey Governor Chris Christie's administration had sort of shut down lanes on a bridge in order to, I guess, further this political vendetta of some sort. And so those kinds of bad faith actions could result in a loss of state sovereign immunity. It's possible that this can also be abrogated by discrimination lawsuits in situations where states are actually receiving federal money, although there's some kind of mixed messages on this question. And of course, the federal government can sue the states, and other states can sue the states in federal court. So, right after the passage of the 11th Amendment, we see this opportunity for the Supreme Court to interpret the 11th Amendment in Cohens versus Virginia. And so in this case, we have these Cohen brothers. It's not these guys. It's different Cohen brothers way, way before them. But they had this contract to run a lottery in D.C. And the law that authorized this was a federal law. And it also allowed for sale of the tickets elsewhere outside of just D.C. So the Cohen brothers were selling these tickets in Virginia, and this was against state law in Virginia. So the state prosecuted and convicted them, and the state Supreme Court actually declared in its opinion that it had the last word on this case, despite the fact that the case relied upon that state Supreme Court interpreting the meaning of the federal law that had authorized the D.C. lottery in the first place. So the legal question to the Supreme Court, it was twofold. The interesting part of the case is this question: does the Supreme Court have the power to review Virginia's ruling? And the holding was unanimous, 7-0 decision, and the court said yes. That the Supreme Court has jurisdiction over any federal constitutional questions, even those that arise in state courts. And this is just, the reassertion of judicial review. Now, after this, in this kind of side note, Chief Justice Marshall also mentions the fact that he thinks the people would be able to sue their own state as well, and that states would not be immune to that. Of course, this was not a question at issue in Cohens versus Virginia, and so this is just dicta, meaning it is just sort of an added commentary that doesn't carry the weight of precedent. And after this part of the decision was done, the court then returned to the question of what to make of the Virginia law, and the court declined to overturn that law. They said that it was fine and that it could stand, and that the penalty against the Cohen brothers could also stand. So this was kind of the first interpretation of the 11th Amendment. A bit later in Hans versus Louisiana, we see them revisit some additional questions here. The state of Louisiana had issued a bunch of bonds to investors, and the state was about to make those bonds invalid, meaning that those investments would be useless and worthless. And so Hans sued the state in federal court under Article 1, Section 10, and the legal question was whether the state can be sued in federal court by its own citizen. The holding in this case was unanimous, and it was no. And the court says, look, I know that Marshall said something about this a while back, but that was all dicta. That didn't actually mean anything. They also do bring up Hamilton's argument from Federalist 81 and said that clearly he had envisioned that this would not, state sovereign immunity would absolutely not be overruled by the Constitution. But that's not the end of it. After this, Congress continues to chip away at state sovereign immunity, and the court mostly helps them out on that. And so we're going to trace a couple of these cases through history. And one of the really interesting parts of this is the abrogation doctrine. And as we'll see, it becomes clear, at least up to this point, that Congress cannot use their powers under Article 1 to abrogate state sovereign immunity. However, they can use Section 5 of the 14th Amendment. And so you might ask, why is that? And part of it has to do with the fact that the 14th Amendment provides distinct power against the states to Congress. And also, of course, this comes temporally after the 11th Amendment. So the 14th Amendment can be thought to amend or modify the 11th Amendment. So we'll see how this plays out. In sort of modern times, the case Fitzpatrick versus Spitzer, this is a 1976 case. And the material facts are this. The case deals with some amendments to the Civil Rights Act. And these amendments allow for discrimination suits against states and for monetary damages to be awarded. So a group of men sue the state for sex discrimination in the state's retirement policy. So the question to the court is whether Congress can abrogate 11th Amendment sovereign immunity under their power in the 14th Amendment. And the holding here is unanimous. And they say, of course, yes, absolutely, the Congress can do that because the 14th Amendment gives this very specific power to Congress over the states to limit them, particularly when it comes to things like discrimination. However, a little while later, we see the case Pennsylvania versus Union Gas. Now, this case is interesting too. This has to do with a coal tar leak that polluted a creek. And the coal tar leak created this environmental situation and became a Superfund site, which meant the federal government actually paid to the state to clean up the mess, and then it went to recoup the funds from the company whose predecessors had caused this leak. The company then sues the state, saying that the state had come into possession of this site and it was the state's responsibility, so the state should actually pay instead of the company. And so the legal question that we're interested in here is whether Congress can abrogate 11th Amendment sovereign immunity under the Commerce Clause. And so here we see a holding, a 5-4 decision. And the court holds, yes, that absolutely Congress can abrogate the 11th Amendment sovereign immunity under the Commerce Clause power. So Brennan writes this opinion, and the main thrust of this opinion is that it's necessary for Congress to be able to do this because it is the only thing that allows for a real remedy that would help to make the commerce power actually have effect. So without it, the commerce power would be ineffectual. Now, you'll notice this is just a few years later again in the case Seminole Tribe versus Florida. You can see it does matter, like we've seen before. It matters who's on the court. Now you can see up here in our little diagram that the folks who are shaded in the dissent are now on the other side of the ideological spectrum. So in this case, we have a very similar legal question. Here, this is the Seminole tribe challenging the state of Florida over their failure to negotiate in good faith regarding gambling negotiations, as is required by federal law. And the legal question here is whether Congress can abrogate 11th Amendment sovereign immunity under the Commerce Clause. So this is exactly the same question as we saw in Union Gas. This time, though, we have a 5-4 split, and it goes the other way. And the court says, no, Congress can't do this. And Rehnquist writes this opinion. He argues that the Commerce Clause does not provide the power to abrogate sovereign immunity. And this is true even if Congress is giving states money in order to regulate the group activities that are in question, which was the case here in Seminole Tribe. So a little while later, we see some of these same questions come up in Alden versus Maine. Now, the precise legal question is a little different, but it ends up bringing up a lot of these same divides. The facts of the case are this. A group of probation officers sue the state because of violations of the Fair Labor Standards Act. And the suit in federal court is dismissed, and so they sue in state court. And the legal question here is whether Congress can use Article 1 to subject non-consenting states to private suits for damages in their own state courts. Now, the holding here, again, it's a 5-4 decision, and the answer is no. And Kennedy writes the opinion here for the majority. They start out by saying, look, the 11th Amendment is actually kind of irrelevant here because it doesn't answer this question about whether Congress has the power to subject states to lawsuits in their own courts. Remember, the 11th Amendment talked about the federal judicial power. It didn't talk about the power of Congress. But Kennedy argues that it is true that it is not in the Constitution whether or not the states retain this sovereign immunity. He argues that it's because it was absolutely obvious at the time that Congress can't do this, so nobody really thought to even put this in the Constitution. And he also argues that allowing Congress to force states to be subject to lawsuits in their own state courts would be even worse for state sovereignty than allowing them to be sued in federal courts. Now, the dissent here is interesting because it brings up a lot of the same issues that the liberals on the court had been arguing for throughout this series of cases. So Studer writes this opinion, and he argues that the majority is wrong because states are not sovereign with respect to these powers that they don't have. So what this means is that Congress clearly has the commerce power for, the power to regulate interstate commerce. This is obviously in the Constitution in Article 1. And he says because this is not a state power, the states are not sovereign in respect to these kinds of issues. So this means, the Fair Labor Standards Act is something that is enacted under the commerce power. And so Maine is not sovereign here. So there's no sovereign immunity for these kinds of questions, regardless if it is in state court or in federal court. And he also notes this is a very long majority opinion and a very long dissent. And these two opinions actually speak sort of past each other, or they address each other's arguments at length. And Studer argues that the majority really cherry picks which of the framers they're going to focus on when they say it was obvious that the states couldn't be subject to lawsuits against their will in their own courts. And he also notes that one of the big problems is that this majority opinion takes us back to the same style of logic that we saw in the Lochner era, where the court refused to acknowledge the expanding nature of the commerce power. And he argues that this is not good. And we're going to investigate this part of the question a little bit later in the course. So to give you a sense of Souter's argument here, I pulled this interesting quote. He says, the resemblance of today's state sovereign immunity to the Lochner era's industrial due process is striking. The court began this century by imputing immutable constitutional status to a conception of economic self-reliance that was never true to industrial life and grew insistently fictional with the years. And the court has chosen to close the century by conferring like status on a conception of state sovereign immunity that is true neither to history nor to the structure of the Constitution. I expect the court's late essay into immunity doctrine will prove the equal of its earlier experiment in laissez-faire, the one being as unrealistic as the other, as indefensible, and probably as fleeting. So here, Souter is sort of calling to the future, saying he anticipates that this will also be looked back upon as a mistake and a complete misreading of what is needed in society and what the Constitution actually requires. All right, that's all for today. Have a good one, and we'll see you back here next time.